Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon everyone, and welcome to the latest episode of Business Legal Lifecycle TV. As always, I'm Craig Mason and I have with me
Jeremy Stretton. How is everyone going today?
Welcome for today's episode. Today it's about engaging with your clients, and we're also going to discuss unfair contract terms. So this month we're talking about phase 3, which is the initial client phase. So obviously what we're talking about is engaging with those clients and having documents. So obviously it's a legal show, so we're talking about some legal things today, about what you need to do to engage with your clients successfully and hopefully, govern that relationship going forward, and hopefully nothing bad happens and you need to rely on these sorts of things, but it's better to have them there in the first place. So we're going to go through certain elements of what we see is important in this area. And starting off, Jeremy, I think there's some slides here, and you're going to kick off with an application form or credit application process.
Yeah, that's right. Thanks, Craig. So yeah, the application form is basically something that's used in business if you're going to be providing credit for someone. So some businesses don't need an application form, but a lot of businesses actually use them. So if you've got someone, if you're running a shop and people are coming into your business and buying goods from your shop, well, you don't need an application form unless you're going to provide those goods on credit. So an application form is a really important document though to get right, because if you don't have it right, if you don't have the right format, if you don't get the right information, then it can be very hard to enforce your agreement later on. So an application form has things like your details on it. It has who's actually buying the goods or services from you. It's really important that the person who that is properly defined in the agreement. So we talked about structures in our previous shows, and if you're interested in seeing any of our previous shows, check out businesslegallifecycle.com.au/BLL-TV, and there's a list of TV shows. We'll put that in the show notes as always. So structures are really important. So you need to make sure that the entity that enters into the agreement with you is actually one that can be sued. So and is actually one that operates the business. It's no good having a business name, for instance. A business name in Australia is not a legal entity. A business name just gives you a right to trade using that name in the country. And so you can't just have a business name. So it needs to be a company, an individual, a trust. If it's a trust, you need to make sure you get the trustee details, because at the end of the day, the trustee is the one that if you're not paid, then that's the person you're going to sue. And really that's what we're talking about today is what do we need to put in place to protect you and your business from being, if someone doesn't pay you and you need to commence proceedings and sue them for the loss that you've suffered because they haven't sued you. So whilst a lot of people don't like going through this process and don't see it's necessary, it really is to make sure that you protect yourself. So an application form is really important, and it's really important too in application forms and engagement letters, which I'll talk about in a minute, not to just use the precedent someone else has provided. So it can be very tempting if you're just starting out in business. Costs don't want to spend much money. You want to keep your costs low. You don't want to just go and copy another business that's like yours with their application form, because you don't know what you don't know. You don't know what mistakes there might be in that, and you want to make sure that you get that document right. So this is a time to actually, really early on in the business legal life cycle, engage with your lawyer. Make sure that you've got an application form that's binding, that gets all the right information, properly defines what you're doing. Because if you don't, then it can be very hard down the track to get someone to re-sign another application form, or worse yet, if they just stop paying you for some reason 3 or 4 years down the track, then you can be in a lot of trouble. Craig, anything else that you wanted to add on application forms?
Just to reiterate, really important, get all the information in early, because you won't be able to get it down the track if they won't give it to you. So get it at the beginning, not down the track, because you might need some of that information. And one other thing, and that goes with everything that we're going to talk about today, is it's great to give a new customer or client these forms, but you've actually got to check to make sure they fill them out correctly as well. So have a process in place where you're doing your ticks and crosses on things that are actually filled out.
Yep.
Because again, if you don't do that and then you just give them 10 grand's worth of goods on credit, they don't pay and they didn't fill out a particular spot on the application form or didn't agree to something, so you can't go backwards. So make sure you've got a process in place where you're checking these things, and that goes with everything we're going to talk about today. So yeah.
Absolutely, great advice. Yeah, you need to make sure that what you're signing, they've signed is actually binding on them. So for people watching this, I've just moved over to the second slide, engagement letter. If you're listening to this on the podcast, you can check it out at our Facebook page, Business Legal Lifecycle. So an engagement letter is just another form of an application form, essentially. And an engagement letter is often used by professional services, so like us in our law firm, an accounting firm, financial services. They'll be engaged to provide a number of services over a period of time, and it's, as I say, it's a specific type of application form that needs to really have the same kind of things we're talking about. You need to make sure that you're properly engaging with your clients to make sure that they're binding. So for instance, we had a client, an accounting firm client of ours, and they had this common problem where they would set up new entities for their clients, giving great accounting advice. So, their clients would set up different businesses and they'd set up separate entities as they should for each of those businesses. But they had this problem of they only had an engagement letter signed by the previous company. And so what that meant was that when they set up a new entity and started doing work for that, technically they didn't have any engagement letter. So you really need to be careful when you're setting up your engagement letters to make sure that it's actually valid and binding against at least the individuals behind the entities, because we set up these great structures for asset protection, and then God forbid our clients use them against us, so and to not pay our debts. So really what you want to do is get if you're a professional services business, get the client behind the business to engage you, as well as all of their entities, and that way if one doesn't pay, then you can go after all of them. And you can see there that can be very valuable in the case of a business that might have 3 or 4 different businesses. You really want to be able to go after those people. So engagement letters are really important. They're again another thing that, yes, it's tempting just to use something someone else used, maybe your previous employer, maybe maybe a competitor that you've seen the forms for, or maybe a friend. But make sure that if you're not au fait with the laws and the requirements for those engagement letters, because they do vary based on industry, that you get someone to have a look at them and make sure that they're actually valid and binding. So engagement letters are very, very important. Now, on those, as Craig said before, if you get a client to sign an engagement letter, make sure you check it. It seems so obvious, but it's something that's actually can be missed so often. So make sure that you get it checked, make sure that you're properly engaged, so that you can move forward and actually get the right advice for your clients. So Craig, I threw over to you for the application forms, and with engagement letters, is there anything else you think is important?
Yeah, I think same goes. Check it, as Jeremy said, because people might cross things out and then initial it. And so essentially what your engagement letter or your application form is really an offer, and if they change some things, then they're counter offering on what the terms are going to be. So make sure you check it and don't just blindly start providing the services or the goods. So all right, so we'll move on to terms and conditions. So these are the conditions that's going to govern the customer client relationship. So it's important to have terms and conditions for any agreement, and the timing of when these conditions are provided is also important. So there's no point going out to someone's house and doing some plumbing works and then providing them with an invoice with a whole heap of terms and conditions in there about how it's all going to play out. You've already done the work, it's already been completed. You can't just now rely on all these other terms and conditions. You have to give it to them beforehand. So you're obviously going to be giving a quote. A lot of people have a quote with terms and conditions on the back, which is fine. It's sort of one-page terms and conditions, which would cover everything it needs to cover. With a credit application, it's normally a longer sort of form terms and conditions that's provided. And the sort of main things that it's going to have in there is how the process is for cancelling an order for goods or varying that order for goods. How defective goods are going to be dealt with. So the timing behind that, once it's delivered, you've got 48 hours to check it. If you don't do that, then you're deemed to have accepted those goods, those sorts of things. It's going to have in there default provisions. So if someone doesn't pay an invoice, there's going to be things in there about you being able to claim interest on unpaid invoices. You might be able to charge admin fees on unpaid invoices. Again, it's a delicate sort of area, admin fees. You don't want to be just charging 20% of the invoice or something like that. It's got to be a true reflection of your actual cost to follow up that invoice. So if you've got an outstanding invoice and then you send a reminder notice, for instance, what's your cost of doing that? Probably 50, 75, $100, something like that, not something higher, because it's got to be a true reflection of your actual costs. Otherwise you could get into some trouble with penalty provisions. So important to get that right. And again, as Jeremy said a couple of times now, don't just copy and paste from someone else, because it mightn't be correct, and then it might be able to rely on it, or there could be issues. We've seen a lot of people copy and paste terms and conditions, and it's got references to American legislation or some other foreign legislation, or the Hague Convention or something. You've got to make sure that it's relevant to your business. So default provisions are pretty important. We've got interest, we've got admin fees. You might be in there cost recovery clauses if you've got a commercial agent involved as well, or legal fees. So the whole point of the default provisions is to put you back in the same spot you would have been if they had paid it in the first place. So interest, obviously you're getting charged interest from your bank, so you can pass that on and recover that. Admin fees, as we said, cost recovery clauses, those sorts of things. And there's also in there what an actual default is. So non-payment of invoices is one. It could be that your customer has an insolvency event, or there's a default judgment entered against them, or something like that. That can trigger a default, and provided your terms and conditions say, it could mean that all your invoices are payable at that stage rather than just the ones that are outstanding, because you might be operating a 30-day account or something like that. So they're pretty important ones. There'll be things in there about terminating agreements, and we'll touch on that in the next slide about unfair contract terms. But there will be things in there about termination, and it's supposed to be that it allows both parties to be able to terminate for whatever reasons. It's not just one-sided to one party. So make sure you don't have termination clauses that are all to you. And as I said, we'll talk about unfair contract terms next. But yeah, so the whole terms and conditions, you've got limitation of liability, those sorts of things, what warranties you're providing. Jurisdiction clause is a big one too for terms and conditions. Now, a lot of businesses could operate in, say, Brisbane, Queensland, but be doing work across Australia. If there was going to be a dispute, you want to be able to deal with that in Brisbane rather than heading off to, Bendigo or wherever it might be. So important to have jurisdiction clauses in your terms and conditions. That's a pretty big one that we see. A lot of people don't have them, or again, they copy from somewhere else and they come into some issues.
They have a jurisdiction clause in the Netherlands or something.
Yeah, exactly. Yeah, or it's ambiguous and it says, the jurisdiction clause is where the goods were sent from or whatever it might be. So important to really consider that, and as always, take some advice, speak to your advisors about it, and make sure you've got terms and conditions that actually suit your type of business. So, and it can be for goods and services, so it covers all types of businesses, but it's important that you actually have that in place and that you provide it before you enter into the agreement. You can update your terms and conditions, of course, and again, that's if you're on a credit application or credit with clients, then you would be updating your terms and conditions and then sending out a notice to everyone saying, we've updated our terms and conditions, they're available on blah 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 on a website, or you might be giving them a copy, and basically just explaining to them the next order that you put through, these terms and conditions will apply to that order. So the communication there, and you might, depending on how long ago it was, it might be a good time to get everyone to sign credit applications again as well, to get updated details, because as we know, a lot of companies or businesses change structures, so you want to keep up to date on exactly who you're dealing with. So terms and conditions, pretty important. Well, not pretty important, very important. You need those in some form with any initial client that you're engaging with, because that's going to be what you can rely on and what they can rely on going forward in the relationship. So yeah, terms and conditions. Jeremy, do you have anything else you wanted to say about that?
Yeah, I just wanted to reiterate what you said at the beginning, Craig, and I think it's an important point that people, they think, I just provide the terms and conditions with my invoice and the person's bound by those. What a lot of people don't realise is you've got basically three elements to a contract. You've got an offer, you've got an acceptance, and some sort of consideration's got to be paid. So the offer is the actual offer to do the work. The acceptance is someone accepting it, and then actually providing the work is the consideration. If you don't give your terms and conditions, and we see this all the time, if you don't give your terms and conditions until after you've done the work, then they've never, the client or the customer has never accepted them before they do the work. So what that means is that there's no actual contract, just a basic contractual law, because what we're talking about here is entering into a contract. You're entering into a contract with your client or your customer, and the reason that you're doing that is so that you make sure that you get paid and that your rights are protected. So if you haven't entered into that contract properly, then you're going to have lots of problems trying to enforce that contract, and you could end up losing yourself a lot of money. So if you don't understand the process, if you're not sure what we've talked about today, this is the kind of thing that please ask us. For us, it's Law 101 for us, because we've been doing this for well over a decade, 15 years. And so we know it like the back of our hands, but we also know from our experience that business owners don't see this stuff. They don't, you guys don't go through the education that we go through, and it's not top of mind all the time, but we're there to help, or your lawyers or your other advisors are there to help, so make sure that you get advice to make sure that the process that you're following is right. Because we don't want you coming to us or to your lawyer and us having to say, we can't enforce this, or it's going to be 10 times harder to enforce these terms and conditions because you haven't followed the right process. And it's very simple: offer, acceptance, consideration. You have the offer, you have some sort of acceptance of that offer, and some sort of consideration. And those together go together to make the contract that makes it enforceable. So Craig, I just wanted to reiterate that to people watching and listening, that they really, really understand that point, because I think it's really important and it's something that people miss quite a bit.
Absolutely. Because once you've got the process in place, then it's easy to follow. When you start sort of doing one thing but not the other for another customer, that's when you come into problems. But if you've got a process, and it goes along the lines of what Jeremy was just saying, and it has all that built in when you're giving these sorts of things to people, then you shouldn't fall foul of that, and you follow the process and tick all the boxes, make sure you've got a policy in place where you're checking all these sorts of things, and then it should be hopefully smooth sailing from there. That's the plan.
Excellent. Yeah. So let's get off our soapbox and move on to unfair contract terms.
Okay, so unfair contract terms, which I touched on before with terms and conditions. So recently there were some changes, 12th of November 2016, so actually over 12 months ago now. But the changes have started to come through from a case law point of view. So basically what it meant was that you couldn't rely on what is perceived to be unfair contract terms, as the title suggests. So it was all about sort of terms that allow one party to terminate, but the other party not to, as I said before. So it's got to be fair to all the parties. And it applies to contracts of up to 300,000 or $1 million if it's for longer than 12 months. So the contract term is longer than 12 months. So a lot of contracts are going to be covered under this. And the whole point of it is to even up what is perceived as a power imbalance sometimes between a service provider and a customer. So there's examples on the ACCC website about what could be considered unfair contract terms, and as I said, there's a few cases around at the moment that speak about what could be considered unfair. One of the examples is about renewal contracts where you're under a contract for a year and it automatically renews for another year unless you terminate. The example in ACCC is 6 months before, which is, anyone could probably see that's unfair. That if you don't terminate 6 months before, then you're automatically going to be signed up for another year. So it's not that you can't have renewal contracts necessarily, but it's about the termination period. So the recent case of JJ Richards, the waste people, they basically conceded, and it wasn't necessarily tested whether or not it would be unfair, but they conceded that perhaps some of these things were unfair, and one of them was about renewal contracts, and they had a period of time, it wasn't 6 months, where it automatically renewed for the original term, and they had a lot of contracts that were 5 and 3 year terms, so they were automatically renewing for another 5 years in some instances, which everyone conceded was unfair in terms of the new unfair contract terms, and they had thousands of contracts out there with that in it, so they're unable to rely on those anymore. So I believe the process would be that if you're going to have a renewal contract, that you're actually positively getting a response from the customer to say that it's going to renew in 30 days. If you don't terminate by such and such a day, then it's going to be renewed for another 12 months or something like that. I think that's probably the way to deal with that. The other case we spoke about last week in our Legal Updater show was the Ashley and Martin decision that recently came down, and that was considered unfair. Some of the terms, which was essentially that once you got your medical report, you had 2 days to basically make a decision. If you didn't, then you were responsible for the full fee. And the court said, well, it's a costly decision. It's expensive, and that was insufficient time and unfair to only give someone 2 days. I can't remember if it was business days or normal days.
It was business days.
Yeah, 2 business days. So they considered that to be unfair, which again, when you think about unfairness, potentially that well, not potentially, but that seems unfair to give someone that limited amount of time. So you've got to go into the transaction thinking that you don't want to just have everything one side and everything for you. It's easy to do it that way, but you'll come into trouble with the unfair contract terms, and those conditions that you've got in there will be unenforceable. It doesn't necessarily mean you won't have an agreement, but you won't be able to rely on those unfair contract terms, which could be important. So definitely something to consider when you're doing your terms and conditions. And as we've said a couple of times, copy and paste, not a good idea, because you're likely to have some unfair ones in there because you're potentially copying off someone that hasn't got the right advice or has done it some time ago before these sorts of things came in. So pretty important to have a think about unfair contract terms, and I guess the test would be, would you consider it to be unfair if you were the customer? So think about unfair contract terms.
I think it's a good lesson for everyone. There's lots of clever lawyers with lots of clever ideas about making clever clauses, but at the end of the day, the law often steps in to stop unfair things from happening to consumers who may be unaware. Because let's face it, with these terms and conditions and these contracts, so many people don't read them, do they, Craig?
No, of course not.
And that's a good lesson. Read before you sign. so often, yeah, that people say, "Oh, I didn't read those contract terms." Well, no, you're going to be bound by them unless they're unfair. So make sure you read them. All right. So the next one is personal guarantees. So a personal guarantee can also be known as a director's guarantee. Is basically something that a lot of suppliers will ask for, where you're entering into a contract, say through a company or a trust, and they want the person behind that company or trust to personally guarantee that they'll actually pay the debt. Now, this is another area where that has developed over the last 100 odd years since companies were brought in. Because if you watched any of our previous shows, and as we've talked about before, we've talked about where to find them. When you set up a company or a trust, it's a separate legal entity from the people behind it. And the whole idea of that is to protect the people behind it from liability. But what's happened is that a lot of people and business owners would incur lots of debts through their company, and then they wouldn't pay their debt. And so suppliers, landlords were left holding the bag with no way of recovering their debts. So personal guarantees have developed. Now, you might have heard the term director's guarantee. A lot of people think that a director's guarantee only applies whilst they're a director of the company. That's not necessarily the case. There's no right or wrong way to actually have a personal or a director's guarantee. It depends on the actual wording of the agreement. So it's that great lawyer term of "it depends," and it does, because it depends on what's actually written in the document as to when you're actually liable. When you provide a personal guarantee, generally you're providing a personal guarantee for all the debts that company or trust is going to incur for an unlimited period of time, or to a certain debt limit. So you make sure you have a read of it, make sure that you understand what your obligations are, and make sure that you keep a record of all the personal guarantees that you sign. This is something that we're very big on for our clients and customers, to make sure that they have an agreement, a list of the personal guarantees that they've agreed to over the years. If you're running a supply business, if you're running a business which brings in a lot of supplies, you're going to sign lots of personal guarantees. If something goes wrong with that company, and of course we hope it doesn't, but we've got to always think about what might happen in the event that something goes wrong, you could be left with not knowing what personal guarantees are out there, and for years afterwards be chased by creditors that you might have been able to sort things out with if you'd done it at the time. So make sure you read your personal guarantees. Understand that even if it's called a director's guarantee, that doesn't necessarily mean that you're off the hook if you're no longer a director. And in that case, if you do leave the company, usually what you need to do is go and get some positive action from the supplier to make sure that you're released. So what do I mean by that? So we're in our Caboolture office with our law firm right here, right now. If I was to leave our company, I would still be liable as a personal guarantee under our lease, unless our landlord actually released me from that liability. So I would have to go and approach him and make an application and convince him to release me. A lot of people just think if they leave the company that they're no longer liable. And we've had cases before where, how long was that one that we had recently, Craig?
15 years later.
15 years later, they signed what they thought was a director's guarantee that was released when they left the company. And 15 years later, they were being chased by the creditors for the debts for a company they left 15 years ago. Now, there are other arguments that we've run on that as well, so it's not all up you're liable, but think about what that person's going through, and they thought they're out of it. They haven't been in that business for 15 years. It's expanded exponentially over that period of time, and all of a sudden they're up for all these debts that they didn't think they were going to be. So if you are leaving, or you do want to get out of personal guarantees, make sure that you positively get yourself out of them. And as I said before, make sure you have a record of them, preferably a list of all the guarantees, and also a copy of the guarantees, so that if something does go wrong with the company or the business, that you can bring them to your lawyer, and whether it's us or someone else can have a good read through them and make sure of what you're liable for. So personal guarantees, really important, because they come up more and more as more and more people try to avoid debts. More and more suppliers, landlords, they all want personal guarantees. So make sure that you're on top of what personal guarantees are and and what you're liable for. Craig, anything else on that?
Yeah, really important to get. And if someone doesn't want to sign it, then that, you've got a decision there to make whether or not you want to do business with them, because there could be a reason why they don't want to sign it, is that they don't intend on paying. It could be they just don't want to sign it because they know that the liability, and that they don't want to do it, which is fine as well. And then you make a decision then whether or not you want to proceed. So, pretty important document to have in your bundle of documents that you give to all your clients. Alrighty, next one we've got is privacy notices. So you'll see this a lot in credit applications where there's a privacy notice that's signed as well. And the point of it is regarding how you're collecting the information. So on the application form, as Jeremy spoke about, there's a heap of questions in there. Then they're providing answers. So how are you collecting that information? How are you storing that information? How someone can get a copy of that information, how it's disclosed, those sorts of things. So it outlines those conditions. And because the Privacy Act, changes a lot, you've got to be wary of it. Make sure it's updated. There's a lot of privacy notices out there at the moment that refer to repealed sections. So we haven't really touched on it much, but these things need to be updated along the way, and you need to keep getting the advice. So it's not a initial client phase, got all that, tick, move on for the next 10 years and don't look at it again. These are the sorts of things you will need to look at regularly, because things, as we've said, change. So important to update these documents. The other probably important thing with the privacy notice is, provided it's in there of course, is that it might give you the ability to do credit checks on a potential customer if they sign that, or default list. If there's a default, you might be able to list that default, and that goes on their credit file, which obviously can affect that company going forward. A lot of times we see people not pay, there's a default listing, and then a couple of years later they go for a car loan or a new phone or something, and there's a default listing on there, and lo and behold they now are keen to make payments. So pretty important to have those, and you've got to disclose that you're going to do that, and you've got the ability to. So it's got to be in conditions, got to be in your privacy notice. Jeremy, I think that's probably it for today.
Yeah, so I don't have anything to add on privacy notices. So thank you for joining us, whether you're watching this on Facebook, Twitter, Periscope, YouTube, or listening to the podcast. We put it out on a lot of channels. So thank you for joining us. I hope you found some value in that talk about the things that you need for engaging with your clients. This is all part of, as Craig said earlier, the initial clients phase. It's all about making sure that you protect yourself and your business, so that you make sure that you get paid. So we'll be back next week with another show about initial clients. So Craig, do you have anything else to add before we start?
No, I think so. We look forward to you joining us on Monday. Thank you, everyone.
Thanks, everyone.